Welcome back to the channel. Another very interesting question has come up in the comments, so I thought I'd spend a few minutes talking about this. The question revolves around the upcoming changes and reforms, if you will, to the Human Rights Act, and for which there was a press release released on the 14th of December 2021. But I'll come back to that in a moment, and first of all explain why there is an appetite for reforming the Human Rights Act in the first place. And this revolves around the deportation of individuals on the grounds of national security. Under Section 15 of the Immigration Act 1971, the Home Secretary has a very broad power to deport foreign nationals who they believe removal from the UK is a paramount importance for the national security of the United Kingdom. And this interpretation or definition is taken to be that which is conducive to the public good. But in the case of Secretary of State for the Home Department and Raymond of 2001, Lord Slynn said that there is no definition or limitation of what can be conducive to the public good, and that the matter is plainly at the discretion of the Secretary of State. So what, if anything, has caused problems in this area, and why should there be an appetite for reform of the Human Rights Act? Well, this comes back to a case of Chahal in 1996. This was a decision of the European Court of Human Rights in Chahal versus the United Kingdom, which concerned the UK's attempt to deport him on the basis of national security. Mr. Chahal was an Indian of Sikh origin, and the UK wanted to deport him back to India on the ground that he was alleged to be involved in a Sikh separatist activity which constituted a threat to the security of the United Kingdom. He complained to the European Court of Human Rights that if he was sent back to India, that he was going to face torture at the hands of the Indian authorities, and thus argued, among other things, that this made his deportation unfair. Many people will think and argue that the UK can and should have a diplomatic relationship with these foreign nations to ensure that there won't be torture of any individual that's deported. But in 2003, a case which is highlighted on justice.org.uk, which is a charity made up mainly of legal professionals, the case of Ajiza and Sweden, the United Nations Committee Against Torture found that the Swedish government was in breach of its obligations under the UN Convention Against Torture when it returned two asylum seekers to Egypt on the basis of assurances that they would not be tortured. So therefore the Chahal decision, which was against the desires of the United Kingdom, has had a significant and lasting impact on the UK's approach to counter-terrorism and deportation as a significant measure to counter it. The upshot of the decision is that the ruling in the case has prevented the UK government from deporting foreign nationals that it's suspected to be involved in Al-Qaeda terrorism if returning them to their foreign countries meant that they would face the risk of torture by their own government for their suspected or confirmed involvement in terrorist activities. So thus there are two arguments on opposite sides of the coin. One argument is that this is absolutely right because individuals shouldn't be sent to a place knowing that they're going to be tortured. On the other hand, the competing argument for the national security and the very security of the citizens of the United Kingdom should arguably come before that of a terrorist who is intent on harming them. So thus we come back to this press release with the desire to reform the Human Rights Act, which is set out on gov.uk. And reading from the government website, it says that proposed new legislation aims to strike a proper balance between individuals' rights, personal responsibilities and wider public interest. This would be achieved while retaining the UK's commitment to the European Convention on Human Rights. But crucially, the proposed measures will restore Parliament's role as the ultimate decision maker on laws impacting the UK population, allowing more scope to interpret how we, the United Kingdom, interpret the rulings of the European Convention on Human Rights. And what this means in essence that if a decision is made in Strasbourg that would prevent the United Kingdom from removing individuals that are suspected or known terrorists, it would no longer prevent the United Kingdom from deporting such individuals if it is in the interests of the security of the UK and its citizens. The press release goes on to say that it will restore a common sense approach in vital areas of the UK's ability to deport foreign criminals like drug dealers and terrorists, where too often human rights laws are exploited to avoid deportation. It goes on further to say that the proposals achieve this by restricting the rights available to those subject to deportation orders, strengthening the existing legal framework or limiting the grounds on which deportation decisions can be overturned. The press release says that it's estimated that as many as 70% of successful human rights challenges are brought by foreign national offenders who cite a right to family life in the first instance when appealing deportation orders. And this approach even proved successful in the case of a man who had assaulted his partner and paid no child maintenance support to his family. It says that the UK will remain party to the ECHR and continue to meet its obligations under the Convention and all other international human rights treaties. However, it says that ministers will ensure that the UK Supreme Court has the final say on UK rights, making clear that they should not blindly follow the Strasbourg Court. It will mean that rights are interpreted in a UK context with respect for the country's case law, traditions, and the intention of its elected lawmakers. So in short, the proposed revamp of the Human Rights Act, for which the government is seeking a consultation, will ensure the authority of the UK Supreme Court when making decisions of national security, such as whether to deport known or suspected terrorists. So I hope that proved to be a useful explanation. Please do subscribe, and thank you for watching.